In this video, I discuss medical malpractice. I will cover topics such as how lawyers select their cases, how much it costs to hire a medical malpractice attorney, how much time you have to file a case, and of course, I define medical malpractice. I'm John DeGasperis. I'm a medical malpractice attorney based out of Kingston, New York. I have handled hundreds of personal injury and medical malpractice cases, and I have recovered more than $30 million on behalf of my clients. So what is medical malpractice? Medical malpractice is medical negligence. A medical malpractice case requires proof that the treating physician deviated or departed from the standard of care or practice within the community where he or she is practicing. There must also be proof that the physician's departure from the standard of care resulted in harm or damage to the patient. Now, to be clear, not all medical malpractice cases center on the negligence of a physician. Other medical professionals can be negligent as well, such as nurses, therapists, counselors, and medical institutions can be negligent as well, such as a hospital. Thousands of medical malpractice cases are filed across the nation every year, and many of these cases result in substantial sums of money being paid to the plaintiff of the case. In fact, in the year 2018, medical liability insurance companies and healthcare institutions across the nation paid more than $4 billion worth of settlements and verdicts to patients who were harmed as a result of medical negligence. Now, even though these cases can be valuable, medical malpractice cases are some of the most challenging tort law cases that I handle every year. And for that reason, lawyers like myself are incredibly selective about the medical malpractice cases that they accept and handle. In fact, I reject an overwhelming majority of the inquiries that come to my office every year. Why are medical malpractice cases so challenging? There are a number of factors. One of the primary reasons these cases are challenging is because they are vigorously defended by the physicians who are the targets of these cases. Physicians are obligated to report to the federal government any finding of negligence or any adverse consequence that comes from a medical malpractice case. For that reason, they vigorously defend their reputations. Another reason why these cases are challenging is because they're complicated fact patterns. The cases involve science and medicine, and these topics are complicated and at times difficult to follow. Another reason these cases are difficult to handle is that they are very expensive. Every medical malpractice case requires at least one, probably more than one expert witness, and these cases are definitely more expensive than your average personal injury case to litigate. Another reason these cases are difficult to handle is because the lawyers who are hired to represent and defend the physicians and other medical professionals are some of the best lawyers that I confront on an annual basis. These lawyers have a lot of resources at their disposal, a lot of experience, and they're very smart people. So when hiring a medical malpractice attorney, I recommend that you hire someone who handles medical malpractice cases almost exclusively. Another reason medical malpractice cases are challenging is because they're time consuming. I estimate that the average medical malpractice case lasts twice as long as your average personal injury case. This is because the cases are complicated by nature, and the defense attorneys and medical liability insurance companies often want to see the injured patient's medical history, and that requires a lot of time and resources to go back into their medical files to learn more information about the victim. Every medical malpractice case requires an expert witness. In fact, The law requires an attorney to hire a qualified physician to review the case before filing suit. In fact, the lawyer has to file a certificate of merit upon filing the lawsuit. The certificate of merit confirms that the attorney hired a qualified physician to review and analyze the case, and that the physician has a good faith basis to believe that the treating physician or medical provider deviated or departed from good and accepted standards of care. The only time an attorney can file a medical malpractice case without first having the case reviewed by a physician is if there is virtually no time left within the statute of limitations. In that case, the attorney would still file a certificate of merit, but in this situation, the attorney would certify that he or she had virtually no time left and had to file to preserve the statute of limitations. But even in that case, the attorney will have to have the case reviewed by a physician within 90 days or so, and then subsequently certify the case as having merit. At the end of the day, every medical malpractice case must involve an expert witness. You see, lawyers, we're just the trial lawyers. We're just the mechanics who get the case through the litigation process. We need a medical professional to inform us about the medicine that is at hand and to help us understand how and when the treating provider deviated from good and accepted standards of care. So a good expert is critical to a good medical malpractice case. Having handled many medical malpractice cases over the years, I've seen certain trends with respect to the various types of medical malpractice cases that occur. Here are a list of some of the most common types of cases that I see in my practice: surgical errors, misdiagnosis, failure to diagnose, OBGYN and birth defects, and prescription drug errors. These are the most common types of medical malpractice cases. However, the fact patterns surrounding medical malpractice cases are highly variable, and there are a number of other circumstances under which someone might qualify for a medical malpractice case. You should always consider contacting a qualified medical malpractice attorney if you believe you've been the victim of a medical malpractice case, even though your situation may not be one of the common types that I listed above. So, how much time do you have to file a medical malpractice case? Well, New York state law requires that you file medical malpractice cases within 2 years and 6 months of the date of negligence. This is an abbreviated statute of limitations as compared to a 3-year statute of limitations that governs most other tort law claims such as general negligence. Now, there are a few exceptions to the statute of limitations, one being where the physician leaves behind a foreign object after a surgery, and the other would be a misdiagnosis or failure to diagnose cancer. If a physician fails to diagnose cancer, the statute of limitations could be extended. I would never bank on one of the two exceptions applying to the facts of your case. You should always assume that the standard statute of limitations of 2 years and 6 months will govern your case. You must act faster if you believe you've been the victim of medical malpractice as compared to some other accident or injury, such as a car accident. If you think you've been the victim of medical malpractice, you should contact an attorney immediately, because attorneys like myself, we insist on having as much time as possible to investigate and evaluate these types of cases. How much does it cost to hire a medical malpractice lawyer? Well, normally a personal injury lawyer would work on a contingent fee structure. The lawyer would recover as a legal fee 1/3 of the gross settlement. The lawyer would also be reimbursed for his or her costs and disbursements. The lawyer doesn't get paid unless the client gets paid. Medical malpractice attorneys work under very similar terms, but there's a significant difference with respect to the legal fee. You see, we work on a sliding scale. The more money we get for our client, the less money we recover. The percentage that we recover slides downward from 30% all the way down to 10%. You want to make sure that when you hire a medical malpractice attorney, he or she is providing you with a retainer agreement consistent with this sliding scale fee schedule. There are limited circumstances where the handling attorney could apply to the court for a fee greater than what the sliding fee schedule allows for. The attorney does have a burden to demonstrate in good faith that he or she believes that the case presented extraordinary circumstances such that the attorney did not receive adequate compensation. This is rare, but you should know that there is a possibility that your medical malpractice attorney could receive more than what the sliding scale fee schedule allows for. Many of the telephone calls that I receive from people wondering if they qualify for a medical malpractice case really just involve complaints by the patient about their experience or care. Most often though, these complaints amount to nothing more than customer service issues. We also see situations where the doctors were in fact negligent, but the negligence doesn't result in harm. I nonetheless give these people my time and I talk to them about the facts and circumstances surrounding their medical care. I feel that these people deserve someone to listen to their stories, and by giving them my time, I think that they better understand the legal process and why they may or may not qualify for a medical malpractice case. My point is, if you feel that you have been the victim of medical malpractice, you should contact a qualified attorney. Again, I will reiterate that you should contact someone who is experienced handling medical malpractice cases. They are extremely complicated, challenging, and expensive, and you want to make sure that you find an attorney who is comfortable with handling medical malpractice cases and a long and arduous litigation process. Good luck.